The push for reform of the powers of the Supreme Court is not new, and has in fact been part of the agenda of the right for a decade or more. There have been numerous legislative proposals over the years to even make modest reforms to the court, all of which have been shot down by the legal elites. So this is not a new issue. Even in 2016, Yair Lapid said, the power of the court to decide any case, without standing is intolerable. Gideon Sa'ar has spoken out against it. So this is not a new issue, and it did not spring out all at once. I would, in terms of the timing, I think it's important to remind people that Israel has had 5 elections in the last 6 years. In other words, there's been a period of extraordinary government instability, and that would make the past 6 years just a time when serious legislative initiatives like this could not have started. So let me explain a bit about the need for these reforms and what the status quo is, because the status quo is itself a significant problem for democratic self-governance in Israel. In Israel, the Supreme Court has powers unlike any court in the world. So to start off with, Israel does not have a written constitution. It has what's called basic laws, which are not constitutional laws because they're not passed by a constitutional process. So you might have heard of basic laws, but what's important to know is they're passed by a pure majority. In other words, you can have a basic law that's passed 2 Knesset votes to 1 if they decide that's a quorum. Indeed, so the default in Israel is what's called parliamentary sovereignty. That is not an unusual thing. That is the case in most British-based parliamentary models. In other words, court traditionally has not been able to fundamentally override the parliament because the parliament represents the people, and the people are sovereign, right? Just like in the United States. So the Knesset in 1995 announced that a basic law that had been adopted a few years ago, called Basic Law Human Dignity, gives it the power to strike down laws of the Knesset, and in fact gives it the kind of judicial review powers that the United States Constitution confers on the Supreme Court. Now, in Marbury versus Madison, when the Supreme Court formally announced that it has power over judicial review, it explained it very simply. We have a written constitution, someone has to interpret it. Israel doesn't. But the Supreme Court gave itself the power of judicial review, at least in certain matters, mostly dealing with human rights. If they had stopped there, I think it would be illegitimate, it would be an usurpation, but we would never have gotten to this crisis. They did not stop there. Also, throughout the 80s and into the 90s, the Supreme Court got rid of any restrictions on who and what kind of cases it can hear. In America, courts can't just decide general policy questions. They can't decide questions about foreign relations, about military tactics, and certainly not about the actual discretionary political choices of the government, like who can be a cabinet minister. In Israel, the court got rid of any of those limits, so anyone can basically bring a case in the Supreme Court saying, I think the government is doing something wrong. And the Supreme Court can review that no matter what and decide whether they agree. Things like who can be a cabinet minister, who can be appointed to government positions, what the path of the separation barrier shall be, and so forth. So they basically made themselves a roving commission with a mandate as broad as the legislature to decide any policy issue. If they had just stopped there, we wouldn't be here. Then they went on and said, aside from striking down laws because they conflict with this other law that they claimed is constitutional, they can also stop any government action, not legislation, but action, administrative action, because they disagree with it, because it's unreasonable. Now, in America, when a court reviews government action for reasonableness, they say, could a reasonable person have made this decision even if we disagree? Would you have to have been crazy to make this decision? In Israel, it's almost the opposite. Right? They say, would we be unreasonable to decide it should be different? No, we wouldn't, so it should be different. And under that auspice, they have vetoed vast numbers of government actions. If it had stopped there, we wouldn't be here today. The court only hears 10,000 cases a year. It's a huge number. It's a huge number, but that does not give it the power to control every single aspect of political life. So what they did is they created a doctrine. Again, none of this is based on law or statute, where the Attorney General, who is not selected, by the government, selected by a bureaucratic committee, and then appointed by the government, a committee on which the Supreme Court is represented, in which they have a functional majority. So he's essentially a commissar of the Supreme Court in the government. The Attorney General can veto any government action, not through a formal veto action, but by sending basically a one-sentence letter saying the action is problematic. They need not have legal argument. And that action is dead. If the government wants to do it anyway, the Attorney General will not represent the government in court, will argue against the government in court, thus depriving it of legal representation, and can prevent the government from hiring private counsel. It allows any single government action to be blocked at any level of government. And this is paralleled at every level of government by each government's general counsel, who is not answerable to that government, but only to the Attorney General. So there is an entire parallel bureaucracy throughout the government of legal officials answerable not to whatever department they're in, but to the Attorney General, who can veto government action for no particular reason. Then it's starting to get serious. More recently, the Supreme Court went even further, and this was just in the past few years. Traditionally, if you criticize the power of the Supreme Court, what the defenders of the court, Israeli law professors, would say is, the Knesset, even if they didn't explicitly grant them this power, obviously they acquiesce to them having these powers because they can always make a basic law changing things. A few years ago, in the nation-state law case, the Supreme Court said they also have power to review amendments to basic laws. In other words, they're claiming they can strike down what they call constitutional provisions as unconstitutional.
Right.
That there's an unwritten higher constitution.
Right.
And it's like if the Supreme Court could reject the 14th Amendment after Congress passed it, could say, you know what, we don't like this.
No, that is an absurdity that many people have jumped on. And with that as a parting shot, so to speak, Michael, I want to ask if what Eugene has just said and what you've heard, has he made a prima facie case for the need for judicial reform? And
he's made at least a prima facie case. And what jumps out at me is the strangeness of stepping into a system like this after having been used to the system in the United States, where courts are constrained by a written constitution and by doctrines that of what is suitable for what's called what is justiciable. That is, what is suitable for review by a court and what is not. That's a very important concept, certainly in U.S. courts. The court will not consider matters that it considers political questions. It will consider only, and this is a constitutional principle, cases and controversies. That is, actual disputes between actual people or entities where somebody has an interest. You can't simply go into court and decide that you want to claim that the government has done something wrong. But it will decide only cases and controversies, and will decide only matters that are justiciable. That is, matters that can be decided by reference to an objective standard. What is reasonable and what is not reasonable is not an objective standard. When you join that with the unconstrained power of an attorney general, who in the United States is supposed to represent the government and defend the government's interest, but apparently in Israel is not bound to do that, and in fact can oppose the government and deny the government any legal representation by refusing to permit them to hire private counsel. You have a situation in which the Attorney General and the Supreme Court essentially exercise at least a veto power over everything that happens in the country.
Can you give us a sense of what the goals, when the smoke clears, and if reform is done reasonably approximating what the proponents would like to do, what are the goals that they would be hoping to have accomplished?
The goals are basically to introduce a modicum of democracy into Israeli politics and to create checks and balances. So everyone says checks and balances are needed, right? That's one thing everyone says they agree on. But nobody can identify any checks on the court. Now, there are simply none. So on one hand, they wield vast power and can annul the decisions of democratically elected legislators. On the other hand, they are completely outside the democratic process. So the goal is to so currently, half of Israel feels that elections don't really matter for them. And that's a terrible feeling. That there's no way that their input can be felt, because if a left-wing government is elected, they will naturally implement left-wing policies, which is legitimate. And if a right-wing government is elected, they won't be able to implement right-wing policies because of the Supreme Court's political slant. And I think now we need to touch on a crucial point: how the Supreme Court is selected, which is also unique and is perhaps the most problematic thing. In America, let's say the Supreme Court makes a big and important decision that much of the country regards as mistaken. Take Roe versus Wade, for example. They don't have to say we're moving to Canada. They don't have to engage in civic unrest. They can say there's a democratic way of dealing with this, which is slow, right? Which is not radical, because you can't just throw out a decision of the court. But instead, you can vote for presidents who are going to appoint judges who are committed to a judicial philosophy that is different, and hope for a different result. It will take decades. In Israel, you can't do that, because the judges control appointment to the court, and they have a veto over their own colleagues. So if you were the court who decided Roe versus Wade, would you allow on judges that are against Roe versus Wade? No. The current selection mechanism is controlled by the court itself.
Right.
And, on one hand, the court has vast power. On the other hand, it appoints itself. And what does judicial independence mean? I'm sure Judge Mukasey can talk to this. In America, judicial independence is life tenure, right? That you can't fire them, you can't change their salaries. Right. In Israel, no one is talking about changing that. That's in the books. No, the only question is who appoints them initially.
Right.
And no one is suggesting that the current government should appoint all the judges. Right. The suggestion is, when this government is in office, it should appoint at least some of the judges, but not too many. And when the next government is in office, it should do the same thing. Anything but the judges. And the position of the opposition is no. It's sacred that the judges control the selection of the judges. That is why the opposition is fundamentally against any kind of change, because why should they give up total power over everything?
But that the bill, if passed, would accomplish four principles. Number one, as you pointed out, it would allow the government to have majority control to appoint at least the first two justices. Number two, it would end the judicial veto over selection. Number three, it would eliminate the bar association's participation in the process, because the Bar Association was seen to be highly conflicted and basically a shill for the justices themselves, a built-in voting power for the justices themselves. And finally, it would change the process, the selection of the president of the court, from an automatic seniority process to one where the government would decide who the president of the court would be.
The point about the Chief Justice is very important, the president of the court, as it's called. In America, of course, the Chief Justice of the court can be picked directly by
the President of the United States.
But in Israel, actually, they have a process of picking themselves, which is a seniority-based process, which is not based in any legislation. Right. It's not even a judicial rule. It is a custom of the Supreme Court that they are now claiming has constitutional status and cannot be changed, perhaps by the Knesset. The reason this is really important is because their Supreme Court president has vastly more power than the American Chief Justice.
Right.
In particular, they can assign judges to cases. And since there's 15 members of the Supreme Court and they sit in 3-judge panels, even having 1 or 2 or 3 or 5 conservative justices on the court doesn't really help much so long as the presidency, right, is in the hands of the judicial establishment, because they can assign important cases to panels as they see fit, and that is a very important power.
Right. So, Michael, I'm very interested to get your perspective on this, because you have an unparalleled one here, both as the former chief judge of the Federal District Court of the Southern District of New York, arguably the most prestigious district court in the United States, but also as the Attorney General of the United States.
Well, I would think that it's basic to any proposal for reform that the process be opened up to some influence of the democratic system. In the United States, of course, justices of the Supreme Court are nominated by the president and must be approved by the Senate. That is a 2-level political process. And then, of course, they serve, as the commission says, during good behavior. As I understand it in Israel, once a judge is appointed, that judge can serve until they're 70 years old. Is that correct?
Yes.
Yeah.
Okay. So there is no more control by the appointing power in Israel over what a judge does or doesn't do than there is in the United States. There is independence of the judiciary in that respect. I assume that once a chief judge or chief justice is named in Israel, that person would continue for the duration of their service. Is that correct?
Yes.
Then it's really a very minor, it seems to me, adjustment, or certainly not an anti-democratic adjustment, to say that in the first instance, the government that is in power when the chief justice is appointed can appoint the chief justice. The same as happens here when a vacancy occurs in the office of chief justice. So I don't see that as anything improper. Quite the contrary. And I should finally point out that even in the United States, there have been presidents who have appointed justices and chief justices who have then pronounced themselves disappointed with what those justices and chief justices do.
Right.
I'm not saying that would necessarily occur in Israel, but certainly there's nothing to stop it. Once someone is appointed to the court, they can, for the remainder of their tenure, decide cases as they believe they should be decided. And that's the very definition of judicial independence, and that would not be endangered at all by this proposal.
The current system in Israel is not replicated anywhere else in the world. Am I right about that?
There's aspects that are replicated, but the combination of vast power and lack of democratic control is not replicated. And I just want to say something about the history of this. When people say, what's going to happen if we make these changes? So again, first of all, the reform is already not the reform. Now all we're talking about is whether the government can nominate 2 judges to the court that the court doesn't have to agree with. That's the question. Whether that is such a modest, such a compromised, and such an incremental change. And I want to point out that the current status quo was never agreed to by the people in any way. You know, with the possible basis of their first action based on basic law of human dignity, everything else they have done has been absent any legislation whatsoever. So everyone says that we all agree that there should be a national consensus, things should be done by consensus. And I agree with that. Things should be done by consensus. And given the absolute lack of any consensus to the court's power grab, we should erase that and then, move forward. I want to say that, we're not talking about turning the clock back to 1948. We're talking about turning the clock back to 1995.
Correct.
And nobody was saying that Israel was not a democracy back then.
That's right.
And,
right.
that is in fact when all of this started.
Okay, so speaking of consensus, let's shift our focus to the reaction that the proposals have generated, particularly some of the arguments that have been made against them. In a great example of what I would call Orwellian projection, the opponents of reform, any reform, labeled the initiative as profoundly undemocratic. This seems definitionally strange since the proposals are put forth by a duly elected and constituted government representing the majority. However, what the opposition might mean is that they perceive the Supreme Court to be the sole guardian against tyranny by the Knesset, whether it is to destroy minority rights or to create arbitrary laws that would, in the opponent's view, represent a tyranny of the majority. I would ask each of you to address this mindset and these accusations, but before I do, I want to just quote something that Thomas Jefferson said, having to do with his very strong feelings about the potential for judicial tyranny. In a letter to Thomas Jarvis in 1820, Jefferson wrote, quote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so, and their power is the more dangerous, as they are in office for life, and not responsible as the other functionaries are to the elective control." So, Michael, do you have a sense, a take on this idea that only the Supreme Court could be the guardian against tyranny?
So long as there is a democratic system in Israel that produces a Knesset that passes laws, and the members of the Knesset are democratically elected, I don't see how there is a danger to democracy from any of this, number one. Secondly, a court has to have some objective standard to use when deciding cases. It cannot simply say that this is the result because we said so. It should not be able to say that. And if, to the extent that any of its decisions involved policy judgments, at the very least, people ought to be able to say that the judges appointed to the court were appointed with some consideration of what the political views were of the electorate in the large. They can't say that under the current system.
I would actually say something a bit sharper. It is very common for those who seek authoritarian rule to claim that they are coming to ward off against anti-democratic threats. Mm-hmm. As a matter of fact, they have come, the opposition is basically saying, when we say democracy, we don't mean democracy like people get to vote things into law. We mean democracy like a system in which certain results are going to be produced. Mm-hmm. Now, they're talking about various kinds of rights protections. The problem is the Supreme Court is not a great protector of rights. They shut down an opposition radio station. They have changed the status quo in a way to restrict religious observance in public by the ultra-Orthodox. And I want to make another point. If they're saying that being appointed by politicians makes you dependent on the politicians, being appointed by judges then would make you dependent on the judges. And that's, in effect, much worse. Because the judges aren't going to change over time. Politicians at least change over time. So you're dependent on different politicians, and you can have different factions on the court who can call each other out.
So another beef about the proposals is that the ones that are front and center now are really designed to help the prime minister with the legal cases that are pending against him. A few days ago, a law was passed in the Knesset that would eliminate the ability of the court to remove a sitting prime minister and relegated that role solely to the Knesset. Last Thursday night, the prime minister referenced that law by saying his hands were no longer tied in terms of being involved with judicial reform. The next morning, the Attorney General said that he was still barred from involving himself in judicial reform as it would be, per the Supreme Court's ruling, a conflict of interest. Eugene, Could you elaborate on what you think the Prime Minister was referring to when he said that he's no longer bound or his hands are no longer tied? And what possible impact would these laws have on the legal cases that are pending against him?
These laws have absolutely. First of all, let me start with the impact on the legal cases. It's absurd. He is being currently tried. He has been on trial for many, many years. So many years, it would be absurd in America. And the reforms have nothing to do with his case, because we're talking about appointments to the Supreme Court, not appointments of the judge who is already presiding over this case. That judge is there. There is a case. It is being presided over. It will finish. So the argument is that if he is convicted in a year or however many years this will take, and he brings an appeal to the Supreme Court, maybe one or two of the judges on the panel might be judges that he depicted, but also it's a fairly far-fetched scenario. None of these things have anything to do with criminal law, none of these reforms. Now, at the same time, the Attorney General, as soon as Netanyahu took office, launched what I would call decapitation attack on the government, declaring that the Prime Minister has a conflict of interest and is thus incapable of dealing with these issues, and is partially incapacitated, basically, under Israeli law. So for the first 2 months of this matter, the opposition, Lapid Gantz, could get up and speak about this, and the Attorney General had, without any judicial procedures, just through a 2-page letter, basically fired the Prime Minister in part, prevented the Prime Minister from being Prime Minister from the single most important issue in the country. Now, needless to say, the Attorney General has a similar, massive direct conflict of interest, because her own powers would be affected by some of the proposals.
Michael, does this all strike you as something like out of Alice in Wonderland? It must sound rather absurd to you, given
it really does. I mean, I feel as if I've stepped through the looking glass. The question of when or whether the Prime Minister can be incapacitated if his trial ends adversely to him is entirely hypothetical. And he was elected, as I understand it, on a platform that included putting in place certain of the proposals that we're talking about now and that are being considered. For the Attorney General to say that, notwithstanding that he was elected with that platform, he cannot do what he said he was going to do, or he cannot help do what he said he was going to do, is simply otherworldly. And talk about anti-democratic. I mean, that is the nullification of the outcome of a democratic election.
Right. I want to move to another area of a lot of contention, and Eugene, you pointed this out, and that is that there has been no negotiations here. And one cannot shake one's own hand. You can't negotiate with yourself. But the sense among the interested public is that there has been no conversation. There's been no meaningful negotiations that have gone on here.
There's a reason the opposition has said they want, the whole thing frozen before they talk. Because once legislation loses its momentum, it basically gets derailed. It also allows the opposition more time to mobilize. The protests continue. The opposition is interested in one thing. Now, it's not a bad thing for it to be interested. It's traditionally the goal of the opposition in parliamentary democracy. The opposition is not interested in compromise. They're interested in bringing down the government. That is, of course, the role of the government, of the opposition. What is tragic is that they are missing an opportunity for a true national consensus on important issues, and that they seem willing to endanger the economic and military health of the country to bring down the government, which is something that has never been done before.
Right.
But also, why should they compromise? Under the current system, they have all the power. What's the reason to compromise? Right? Now, the one reason would be, if you don't compromise, the government's going to pass this legislation anyway. But they say, but we're going to have a mutiny, right? And we're going to have the army not listen to the government. There have not been negotiations really with the opposition because they don't want to negotiate, the political opposition. So I'm saying the politicians. There have been significant negotiations by representatives of civil society, think tanks, including mine, opposition think tanks, prominent jurists associated with the left, Professor Daniel Friedman, Tel Aviv University professor, former justice minister, definitely a member of the left, but someone who does understand the need for reform. He issued a compromise proposal, all of which I think could have been a great basis for a political compromise if the opposition politicians wanted to compromise. Instead, we got Herzog's proposal, which actually only makes the current situation, codifies the current situation, and wants to make it worse.
Mm-hmm. So, Justice Minister Levin said that if the court were to, if selection process is passed and the court throws it out, overrules it, he's inclined to move forward regardless. And yet, a week and a half ago or so, former Attorney General Mandelblit said that the Supreme Court was on the verge of, quote, issuing an injunction against any legislation. And now, so even if they don't issue an injunction, they just wait until something is passed, and as you say, they overrule it, aren't we now at the impasse of all impasses? Isn't this like, confronting the existential cliff? What happens at that point? How do we pull back from that kind of a cliff?
I think there's no roadmap for that cliff, which is why it's so important, which is why it's tragic that members of the opposition are signaling to the court that it is legitimate to veto. And I'd ask Judge Mukasey if this would even be conceivable in the United States, to veto a proposition about the composition of the committee that appoints the judges, right, and to say it's against Israel's general democratic principles.
The entire situation is inconceivable under the system that we have, because it includes, as I said before, several steps that require participation by the political branches. The president nominates, the Senate approves the appointment of judges, and so this kind of situation could never develop. In addition, the court operates under principles of justiciability and will not decide what it has called political questions. And of course, this is the ultimate political question. So the prospect of something like this being brought before a court in the United States is impossible to imagine.
Yes. Well, again, a lot of this must seem incredibly absurd from your perspective, and it's the kind of thing that, like you say, Eugene, we don't have a roadmap for, and what strikes a lot of us as really very dangerous is the willingness of former leaders to, in effect, be willing to countenance burning down the house in order to stay in power, maintain power, get back into power. And it seems profoundly irresponsible. It seems profoundly disregarding of the of who they have been, guardians, custodians of Israeli democracy. So I would like to ask each of you, is there a salient point or two you want our viewers to take away with them from this discussion?
Is that
Michael?
Unless you have a system that allows for some democratic input into the appointment of judges, then you're going to have a system that is increasingly illegitimate to people who are adversely affected, regardless of their political views. The court has to have some relationship to the citizens whose cases it decides. That relationship is established the way I described before. Yes, they exercise their independent judgment, but only after they go through a political process. And I think that is responsible in large part for why the court is held in high esteem, why courts are held in high esteem. They also decide cases based on objective standards. If you don't have both of those, then what you have is tyranny on one side or the other.
The media coverage of this is vastly disconnected from the reality, and I think one reason is fear sells and fear makes headlines. So people saying like end of democracy is nigh is much more dramatic than we have some suggestions to improve separation of powers in Israel. So be careful in terms of like how you draw your judgments. And we're entering truly testing times for Israel. I pray it comes out well.
Okay.